the Tasmanian government. It was the brainchild of Professor Chalmers, who suggested that we should move away from a statutory model for a law reform body and move to a model based on an agreement. And that's the model that has been used for a very long time for the Alberta Law Reform Institute, and the Tasmanian Law Reform Institute is based on that. And that's the longest functioning law reform agency in Canada. The functions of the Institute include reviewing the laws with a view to their modernisation or removing any defects in them, simplification of the laws, consolidation of the laws, repeal of laws that are obsolete or unnecessary, and trying to achieve some kind of uniformity across the nation in relation to laws. But we don't just apply our attention to what you might call lawyer's law or black letter law. We engage in references that deal with broad social issues as well, like same-sex marriage, for example, or same-sex adoption. And at the moment we're dealing with a reference on bullying. The Attorney General has asked us to look at the problem of bullying, including cyberbullying, to see what can be done to ameliorate that particular problem. In the past, we also looked at whether or not Tasmania should have a Charter of Rights. So that's taking the kind of work we do, all of those issues, well beyond what might be considered to be purely black letter law. When we undertake a reference, as part of the process, we usually prepare an issues paper, which we release to the public, and then we seek submissions from the public in relation to the questions we raise in the issues paper. We also seek submissions from key stakeholders, so we might particularly send it out to one particular body, like in the case of the bullying issues paper, to the Anti-Discrimination Commissioner and the Children's Commission. They might have a particular interest in that area and seek submissions from them. But we get a wide range of submissions from the public and key stakeholders, and then they inform the recommendations that we ultimately make to the government. We write a final report for the government, and after that's gone to the government, it's then up to the government to determine what they're going to do with the recommendations. At that point, we might talk to the media, we might continue to talk to the media about the recommendations we make, but we really step back from the process of implementation. We have nothing more to do with it except an educative function as far as the community is concerned. And if the government wants to talk to us further about our recommendations, then we will do that, including participating in some cases in relation to the actual legislation process as it occurs, and providing advice about different options and the best option. In its 15 years of operation, the Institute has completed 24 projects. As I say, they can cover a broad range of issues, and some of them have been quite controversial. The same-sex adoption reference, for example, caused a lot of consternation in some areas of the community, to such an extent that the then director of the Institute, Professor Warner, received very, very abusive emails from some members of the public, which were of concern to the board. The director has the function of overseeing and supervising all the references that we have, in conjunction with research assistants whom we employ, or students who undertake projects for the Institute, usually free, gratis and for nothing, and of course with the assistance of the Executive Officer, Dr. Helen Coburn, who is in the audience, and she performs a major function within the Law Reform Institute. The participation of students in the work of the Law Reform Institute is particularly valuable. A number of students who are on track to gain a first-class honours degree might be interested in doing a supervised research paper to ensure that they do get first-class honours. which is of use to the Institute. And there have been a number of supervised research papers written by students which have kick-started projects in the Institute. For example, the bullying paper that we are now working on was begun as a supervised research project, and the young woman who wrote that paper as part of her undergraduate degree is now employed by the Institute has been employed by the Institute to write the issues paper and to prepare the final report. What measure of influence does the Law Reform Institute have? Well, some agencies measure their success in terms purely of the degree to which their recommendations are enacted. The Tasmanian Law Reform Institute has had some success in this regard in relation to same-sex adoption, for example. Our recommendations were implemented. There were a very large number of recommendations made in the Institute's sentencing report, and some of the more important ones in that report have been implemented by the government, including the establishment of a Sentencing Advisory Council. The Institute's report on warnings in sexual offences cases were implemented in 2010 in reforms to the Evidence Act. And mistake as to age defence in relation to child sex offences, a number of the reforms that we recommended there were also implemented. We don't confine ourselves to measuring our success by the number of recommendations we make that are actually implemented by the government. We also measure our success by the reaction of the public to what we're doing and to the participation of the public in our references. For example, the reference we had on a Charter of Rights for Tasmania, we received more submissions on that reference than for any other reference that we've had. And interestingly, the vast majority of those submissions were from the general public, not from key stakeholders, and were in favour of the enactment of human rights protection in Tasmania. We also did a project which was not in the form of a reporting process in a normal sense on same-sex marriage. And that was really just done to help inform the debate in Parliament. It didn't contain any recommendations about what should be done. It was simply providing information to the Parliament so that they could make the best decisions based on the options that were available to it. The Law Reform Institute has been described as Tasmania's most interesting experiment with the new law reform machinery. Working for the Law Reform Institute is fantastic because you get to work in so many different areas of the law, not just your own area of expertise. We cover a huge range, from civil law to criminal law to ethical issues and questions about what kind of society we want to create in Tasmania. Our model of law reform agency has been copied in the ACT and most recently in South Australia. We have a lot of challenges in doing the work that we do and in remaining relevant. One of the biggest challenges that we have at the moment is that there is a culture developing of disregarding expert advice. So there is a culture, I don't know whether it's limited to Australia, but it is strong in Australia, in the decline of the influence of experts. And of course, the Law Reform Institute fits firmly within the expert model, the scientific model, if you like, of research. So our method and style is of rationalist legal discourse, which is not fashionable in many quarters. It's not appreciated in many quarters at the moment. So it's not an easy task for us to remain relevant and to maintain the ear of government. We do have in the present government a very sympathetic ear. our present attorney, has a very strong legal research background. So she is very interested in legal research of the kind that we do and in the areas that we are doing. And she's helping us to develop across a patchwork of projects that we're currently engaged in, new approaches to, in particular, criminal justice. So we're looking at problem-solving courts, the possibility of adopting the therapeutic model to deal with recidivist drink driving. We're looking at measures that can assist vulnerable witnesses to testify in criminal cases, particularly children and witnesses with cognitive impairments. We're looking at questions around vulnerable witnesses and therapeutic jurisprudence more broadly. We're also looking at the moment at the defence of self-defence and consent to assault. And I think I'll finish there.